Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now take a look at this. Lawyers reflect on settlement, odds of Judge Torres' ruling today. Holders of XRP and members of the cryptocurrency community are currently awaiting a final ruling from Judge Analisa Torres in the remedies phase of the long-running dispute between Ripple and the Securities and Exchange Commission. On the anniversary of the summary judgment, attorneys shared their thoughts on the possibility of a settlement and the likelihood that Judge Torres will issue an order in the case. The probability of a settlement and a decision today in the case of Ripple versus SEC. Pro XRP attorney Bill Morgan repeated that there will be no settlement in the case because the company has already won numerous important motions, including a landmark finding on the programmatic selling of XRP as not securities as a result of Judge Jackson's decision to dismiss claims about secondary sales of BNB and the SEC visas. Binance action, the Torres doctrine regarding secondary sales of cryptocurrency remained consistent. Even though many people feel that the Securities and Exchange Commission will most likely appeal the judge's ruling from the previous year, he does not think that the SEC will not appeal Judge Torres' summary judgment. In response to a question about the likelihood of a decision being made today, attorney Fred Rispoli stated that there is a 5% probability that Judge Torres will decide on the anniversary of the summary judgment. He continued by saying, her orders are typically submitted in the late morning or early afternoon. So if it is going to take place today, now is the very best time. Rispoli is still looking forward to receiving an order in July. Executives of Ripple celebrate the anniversary of the summary judgment on the occasion of the anniversary of the summary judgment, which was a significant finding that provided XRP a non-security status. Ripple CEO Brad Garlinghouse and Chief Legal Officer Stuart Alderati reflected on the event. Ripple and the entire cryptocurrency industry, which is currently facing an illegitimate battle perpetrated by the United States Securities and Exchange Commission, had a very excellent day, according to Garlinghouse. The agency that he heads promotes the importance of being open and honest. On the contrary, he is known to send individuals to jail for failing to provide accurate information. Despite this, he seems to believe that the principle of transparency does not apply to him or this sect. According to Stuart Alderati, the summary decision that was issued in the litigation between Ripple and the SEC was a pivotal milestone in the legal system that established that XRP is not a security in and of itself. A lack of loyal allegiance to the law and egregious overreach on the part of the SEC was also revealed by the verdict against the agency. D made the following statement about Gary Gensler. Do not let yourself be distracted by the SEC's ongoing efforts to ensnare Ripple and the industry in the litigation trenches. That runway is running out for the SEC. For a significant amount of time after Chair Gensler's departure, Ripple and the entire industry will continue to emerge stronger. The narrative of Ripple versus SEC over XRP has given rise to a great deal of conjecture over the possibility of a truce between the two titans. Ripple's Chief Executive Officer Brad Garlinghouse and Chief Legal Officer Stuart Alderati were seen in New York, which sparked speculation about the possibility of negotiations taking place behind closed doors. This was the beginning of the buzz. A member of the XRP community by the name of Boba Fett asserted that he had seen Garlinghouse and Alderati outside of a federal courthouse in New York. This sparked rumors regarding the possibility of a meeting between Ripple and the SEC to discuss the disagreements that have arisen between the two governments. In a recent piece, Eleanor Terrett, writer for Fox Business and crypto aficionado, made a cryptic reference to a settlement conference which added to the mystery surrounding the event. Terrett, armed with proof, pointed to a document that suggested that even if the next hearing for the Ripple versus XC case is scheduled for April 16, 2024, there may be an earlier attempt to settle matters, even though the date remained elusive. On the other side of the ring, the Securities and Exchange Commission, SEC, is exercising its authority by attempting to obtain a final verdict in the XRP litigation by imposing a large fine of $2 billion against Ripple for suspected violations of securities law. When asked for a response, Stuart Alderati, who works at Ripple, did not hold back. He criticized the demands made by the SEC as being unfair, cited contradictions, and accused the regulatory body of making misleading claims. The fact that Alderati is getting ready to make a strong defense on behalf of Ripple in April is a clear indication that the firm is determined to contest the charges made by the. Despite this, the potential of a settlement meeting is a source of concern. regarding the future of Ripple and the fate of XRP. This is because the legal stalemate is now ongoing, conflict in the courtroom or a settlement. Finding a point of agreement between the two parties will not be an easy task by any means. Ripple's top executives are currently in New York, and there has been talk of holding a settlement conference, both of which are indicators that negotiations may already be in progress. If a settlement is reached, it has the potential to shake up the XRP litigation and direct Ripple's path in the cryptocurrency space. There is a lot of anticipation among members of the cryptocurrency community as they wait for additional developments in this riveting court drama. The pre-trial meeting that is scheduled to take place in April is drawing near, and the future of XRP is uncertain. A significant victory has been claimed by Ripple, the company that is responsible for developing the XRP blockchain and whose native token is XRP, in the ongoing legal struggle that it is engaged in with the United States Securities and Exchange Commission. Ripple was accused of selling unregistered securities after the Securities and Exchange Commission launched a lawsuit against the company in December 2020. The SEC asserted that XRP is a security rather than a commodity. Additionally, the SEC asserted that the blockchain corporation had illegally achieved a total of $1.08 billion through the sale of the token. The disagreement between a cryptocurrency corporation and the regulatory authorities turned out to be one of the most severe issues that this company has ever faced. It was difficult to discern who had the upper hand in the lawsuit. Even after a year of court hearings and motion filings had taken place against each party, nevertheless, James Fallon, who's a member of the Ripple community and a lawyer, has indicated that this is a big win for Ripple in light of the recent developments. In a tweet that he sent out on Tuesday, April 12, Fallon disclosed that the presiding judge, Sarah Netburn, had denied the Securities and Exchange Commission's request to investigate the concealment of documents that were associated with a lecture that was delivered by William Heinemann in June of 2018. Hinman was a director at the SEC at the time. During that period, Hyman acknowledged that Bitcoin and Ethereum could not be categorized as securities. In an earlier statement, the Securities and Exchange Commission had emphasized that Hyman's remarks were his personal beliefs and did not reflect the official stance of the agency. After that, the regulator contended in court that Hyman's speech reflected the official ideals of the agency and not his convictions. As a result, it ought to be protected. However, the speech was either intended to reflect agency policy or it was not. The Securities and Exchange Commission this year is trying to have it both ways. The Securities and Exchange Commission cannot now reject its position because it has insisted that it reflected Hinman's personal views, the judge remarked. It is still ongoing, and the Securities and Exchange Commission has 14 days starting on April 11 to file an objection to the verdict. This is even though this key ruling has the potential to drastically influence the result of the case. The outcome of this case may influence whether or not the Securities and Exchange Commission will continue to pursue charges against cryptocurrency companies for the selling of unregistered securities.